Welcome back to Government Information Gathering. I'm Mike DeBliss, and I'm delighted to have you back here in what is webinar number 4 in this series on government information gathering. We are chugging along at a pretty good pace here, and today we are going to round out our discussion on privileges to IRS summonses and subpoenas. And if you remain throughout the entire webinar, there is a special bonus at the very end. So I know I'm enticing you a little bit, and I'm going to leave you in suspense. So we left off on the attorney-client privilege and work product privilege in our last webinar, and that's where we're going to pick up today. We're also going to discuss the Kovel agreement in this context. So let's begin with the attorney-client privilege. What is the attorney-client privilege? Well, it protects communications that occur between an attorney and the attorney's client. And essentially, neither the attorney nor his client can disclose the substance of any conversations that the two had that were related to lice of any kind. Now there are specific elements that have to be met in order for the attorney-client privilege to protect these communications, and here you see a list of them. The first is that legal advice is sought. The second is that the giver of the legal advice is a attorney or a professional legal advisor. The third is that the communication relates to that purpose, the giving of legal advice. It's made in confidence by the client and by the client. Now, the exception here is that the privilege can be waived. So what's important is to understand who is the person that has the power to waive the privilege. If the client automatically came to mind, then you would be right. The client is the holder of the privilege. To the extent that the client wants to waive the privilege, he or she is free to do that. And that happens, believe it or not, more times than you think. Now for the work product privilege. The work product privilege is a judicially created privilege. And when we talk about judicially created privilege, all we're referring to there is that it was created by the courts. And it is for material prepared or collected by an attorney in the course of preparing for possible litigation. And you'll see the connection in a little while about to the preparation for possible litigation. But the case that first announced the work product doctrine was the Supreme Court case of Hickman versus Taylor. That case was decided back in 1947. So we actually have this judicially created rule since 1947. It was later made into a civil procedure rule, and it's now Civil Procedure Rule 26B3. So, what type of information falls within the work product privilege? It includes opinion work product, meaning assessment of legal positions, and summaries of the testimony of potential witnesses. It's also to be more specific, it refers to tangible things such as reports, models, spreadsheets, and other documents that are prepared in the course of that are prepared in preparation for possible litigation. So you might think of an expert as someone who is creating a report, a model, a spreadsheet for litigation, for trial. Those are the type of That's the type of material rather that would be protected by the work product privilege. Here are two examples of what's not protected under the work product doctrine. The first would be an accountant's work papers. So that's kind of intuitive to what you might expect would be protected based on the category or based on the laundry list of items that I just listed. But unfortunately, an accountant's work papers are not protected under the work product doctrine. Similarly, an email that the taxpayer CCs his attorney on would not be protected by the work product privilege. Now, there are some common issues that arise in cases of both privileges. And rather than go through the issues first for the attorney-client privilege and then for the work product privilege, what I did was I essentially consolidated them, and I'm going to deal with them all at one time. So the four major issues that come up with respect to the attorney-client privilege and the work product are: number one, who is the client? Number two, do you want legal or tax advice? Number three, waiver of the privilege. And number four, the privilege and accountants. So let's dive into who is the client. Now, you might be saying to yourself, why are we going to waste our time on this? Isn't it obvious who the client is? She's the person who has hired the attorney in the first place. So why would there be any confusion about who the client is or identifying the client? Well, I agree. However, there are times, especially in white-collar cases, when the corporation needs representation and not necessarily individuals within. Although more times than not in white-collar cases, it's not only the corporation that needs representation, but also the shareholders and the officers within the corporation that need representation. And just to back up for a second, why would the corporation need an attorney to represent it in a potential criminal investigation? Well, a corporation could be prosecuted criminally, just as a human being could. And as a matter of fact, corporations can be hauled into court and can be on trial. We've seen that in recent years with the number of international companies that have been criminally prosecuted by the government. However, these corporations usually enter into deferred prosecution agreements with the government. But nonetheless, there are some corporations that have pleaded guilty and as a result have been fined exorbitant amounts of money for various activities that they were involved in. So if you're asking yourself if that was a question on your mind, yes, corporations in fact are fair game when it comes to criminal prosecutions, and while they can't be jailed, they certainly can be fined, and fined to the extent that they might be run right out of business. We have seen that as well. So the privilege belongs to the client, but who is the client? Just discuss this. Is it the corporation? Is it the shareholders? Is it the officers? The context that this comes up in, more times than not, is in closely held corporations. And by closely held corporations, what I'm referring to here is where there are maybe just one or at the most a handful of shareholders. These closely held corporations tend to be family corporations. Many of you probably represent them as their CPA or their tax preparer. In essence, the individual or individuals are the corporation. So, who is the client? Well, fortunately, we have some direction on that, and that comes from a case called Upjohn. It says that the attorney-client privilege and the work product privilege belong to the corporation and not to its officers or shareholders. Now, while the courts view the attorney-client privilege and work product privilege as belonging to the corporation, this interpretation sometimes be at odds with the realities of the situation. What do I mean by the realities of the situation? Well, more times than not, the attorney is going to enter into an engagement agreement with the client. And that engagement agreement will specifically state the terms of the representation, and in the very first paragraph will state who the client is. And therefore, this won't be something that is up for up for speculation or something that has to be guessed about. The client will specifically be defined in the engagement agreement. So to the extent that the client happens to be a shareholder in the corporation or an officer of the corporation, that'll be spelled out in the contract of engagement. So that's why it's important to review the engagement agreement because it will explicitly state who the client is. The reason why this sometimes gets a little bit hazy is because a lot of officers of corporations, such as CEOs and CFOs, have special agreements with the corporation within their contracts that state that if for any reason they become subject to a criminal investigation, that the corporation itself will pay their legal bills. So this is why this issue comes up and rears its ugly head. It has to do with the fact that more times than not, the corporation is footing the bill for the CEO and for the CFO when it comes to their attorneys. But under any circumstance, the first thing that should be done is reviewing the engagement agreement to see who, in fact, the client is. Only legal advice is protected by the attorney-client privilege. And we also know that the preparation of tax returns is considered accounting work, not legal work. So whenever a court finds that the substance of communications between a lawyer and his accountant relates to accounting work, then we know automatically that it's not protected. Here's my commentary on that. I'm sure you probably could, you didn't have to think too hard here on what my view of this was. I certainly feel that it's detrimental to the attorney-client privilege. Why? Well, read literally, any legal advice given by a tax preparer that winds up on the client's return it as having been given as part of return preparation. And the problem is this: it's difficult to conceive of any situation where tax advice would not wind up on a return. If I'm the taxpayer and I've hired a tax attorney to give me advice on, the tax consequences of a certain transaction, it would logic for me to disregard the advice that I've now paid this tax attorney to give me and go with some other reporting position altogether. Of course, I'm going to go with the advice that was given me by the tax attorney. And this case of U.S. versus KPMG is so broad as to say that any time the taxpayer follows the advice of the tax preparer, dealing with we're now dealing with we're now dealing with accounting and we're now dealing with accounting as opposed to legal advice, and therefore it's not protected by the attorney-client privilege. So it's a slippery slope and one that's very dangerous. Waiver of the privilege. Now, we talked about this a little earlier. The attorney-client privilege can be waived if the communication is not made in confidence. So let me back up for a second. We talked earlier about who can waive the privilege, and we identified the client as the person who possesses the privilege and who could waive it. But there are also other ways that the attorney can be waived without the client affirmatively waiving it. And that's if it's not made in confidence. So for example, if it's made in the presence of others, or if it's expected that the information will be revealed to somebody else outside the circle of confidentiality. The example that I like to give here comes from my experience as a criminal defense attorney. Oftentimes I meet with clients at my office, in the courthouse, and normally these meetings are one-on-one with me and the client. But there are always times when the client wants to have a family member or a close friend or a girlfriend or wife present during the meetings. And it is during those times when I have to advise the client that the communication is not privileged and that it's not protected by the attorney-client privilege. Not because I'm going to run out and shout from the mountaintops what the client told me, but the fact that there is a third party there destroys the confidentiality of the communication, and therefore makes it vulnerable to to being repeated. That stems from the fact that there is a third party, whether it be a family member or a friend that's present. Now, there is an exception here, and that's the joint defense exception. There is something called a joint defense agreement. And before we go any further, let me just define what that is. In white-collar cases, there tends to be more than just one defendant. There are usually defendants in a white-collar criminal case. And during the course of the case, the attorneys for the co-defendants are going to meet. Not once, not twice, but numerous times. And during the course of those meetings, they will be plotting out their strategy and their theory for the case, especially if they're all going to trial at one time. What the joint defense exception does is that it protects the communications that occur between the various attorneys for the co-defendants. So there is no waiver of the attorney-client privilege under these circumstances, notwithstanding the fact that the communication is being shared between outside the circle of just the attorney and his. And the rationale for this is that the parties are engaged in the formation of a joint defense. So what this means is that what this means is that the attorney can't go running to the government attorney to disclose what the attorney for another co-defendant disclosed to him in a closed door. Now we move on to the privilege and accountants. No doubt the topic that you have been waiting for with bated breath. I know that we have a number of accountants and enrolled agents on this webinar. Generally, and here's where we start, generally there is no accountant-client privilege recognized in federal law. However, in the big accounting firms put a lot of lobbying money to work, and the result was 75-25 being added to the IRC. And it only made sense. I mean, at the end of the day, accountants were virtually the only professionals that didn't have a privilege. For example, there's a doctor, there's a priest parishioner privilege. There is a privilege for virtually every other professional out there, and up until 1998, there was nothing to protect conversations between an accountant or a tax preparer and his client. So the big accounting firms put their lobbying money into getting 75-25 passed. And what 75-25 does is it creates what's called the federally authorized tax practitioner's privilege. And by tax practitioners, that includes accountants, enrolled agents, and actuaries that are authorized to practice before the IRS. So what is so special about FATP? Essentially, it extends to communications with these tax professionals the same privilege that would attach if the communication was with an attorney. I'll repeat that again. FATP extends to communications with tax professionals the very same privilege that would attach if the communication was with an attorney. And here's an example. If a client says something to his attorney that would be privileged under the attorney-client privilege, that same conversation is still privileged even though it takes place between a client and a return preparer. So it's relatively straightforward. Anything that's protected between an attorney and that particular client would protect the conversation, the same conversation between that client and his return preparer. Now this brings us to the birth of the Kovel accountant. Judge Friendly applied this principle to accountants, and he said very simply that an attorney may want an accountant to meet with his client and obtain information directly from him. In these cases, the attorney, of course, needs to be reassured that the information given by his client to the accountant will be cloaked in the attorney-client privilege. So let me say that again. The needs reassurance that the information disclosed by the client to the accountant will be protected or cloaked in the attorney-client privilege, just as if the attorney obtained it directly from the client. And the only way this could happen, of course, is through an arrangement where the lawyer engages the accountant to become part of the legal team. And that, my friends, marks the birth of the Kovel accountant. The burden is on the government to disprove the privilege. In other words, the taxpayer does not have the burden of proof to establish it. So, the next 40 years following this case were very interesting. As we discussed, in the wake of this opinion, it sent shockwaves, of course, through Congress and through lawmakers. The government grudgingly codified Kovel into Section 7525 of the Internal Revenue Code. So 7525 was already there, but what the government did was it took parts of the Kovel decision and integrated them into Section 7525. But don't get too excited. The government only codified some of the concepts that Judge Friendly stressed and ignored the rest. And so, as you can see here, I've got a little monster with some steam blowing out of his ears against Judge Friendly, because he clearly could not have been happy, since he envisioned the privilege as being a lot broader than what 7525 post-amendment reflected. Now, Section 7525 makes some key limitations. And it's important for us to go through these to make sure that we understand them, because this is what the status of Section 7525 is today. First, the privilege is only as broad as the attorney-client privilege. And as we already know, when it comes to tax matters, the attorney-client privilege is narrow. So what does it protect? Well, the privilege protects communications involving tax advice. But beware, when we talk about tax advice, we're talking about tax advice given, we're talking about tax advice given by an attorney, not a tax preparer. So please don't fall into that trap. I see this happen routinely, where tax preparers and even attorneys interpret tax advice to mean tax advice given by a tax preparer. No, we're talking about tax advice given by an attorney. And there is case law that gets into even more specifics when it comes to tax advice. So before a court will find that a tax preparer's tax advice is protected by the attorney-client privilege, it must be, quote, a matter that is sufficiently within the professional attorney. I'll repeat that again. Before a court will find that a tax preparer's tax advice is protected by the attorney-client privilege, it must be a matter that is sufficiently within the professional competence of an attorney. And so stated otherwise, tax matters that are outside the professional competence of an attorney are not privileged. And what would be an example of a tax matter that's outside the professional competence of an attorney? You guessed it, the preparation of tax returns. The second key limitation of 7525, the privilege applies only in non-criminal tax matters before the IRS and non-criminal tax proceedings in federal court brought by or against the United States. And I have to get on my soapbox. I apologize. Please indulge me. If there was ever a time when Section 7525 would be needed most, it would be in number 2, in matters involving, in matters that are potentially turning criminal or that may have already turned criminal. And yet, the privilege doesn't apply in those circumstances. So here's the analogy. It's almost like the absence of police in a high crime area after dark. Just like that is the prime time that you want to see a police officer in an urban, desolate area at dark. They're not there. Just like in number 2, when the privilege is needed the most, when a tax controversy is on the cusp of turning criminal, the privilege is not available. So, under these circumstances, anything said by the taxpayer to his accountant is not privileged. Ironically, Mr. Kovel would not be entitled to the privilege that bears his name. The third key limitation of Section 7525, the privilege applies only to communications between a federally authorized tax practitioner and the taxpayer. As we've already discussed, federally authorized tax practitioner includes those professionals who are authorized to practice before the IRS, like CPAs, enrolled agents, and enrolled actuaries. The fourth and final limitation is that no protection exists for tax shelters. So, what's the takeaway here? The takeaway is this. These limitations, these 4 limitations, along with case law, place a great deal of uncertainty in Kovel agreements. And what I mean by uncertainty is this. While some courts deny the privilege when it comes to communications made solely for tax preparation, others acknowledge an element of legal advice in the preparation of returns. And a case in point is the Ninth Circuit Court of Appeals. They extend the privilege to communications made to obtain legal advice about a reporting position. And by reporting position, the case that I'm referring to dealt specifically with whether an item could be claimed as a deduction. So the Ninth Circuit Court of Appeals takes a tax-friendly approach to the privilege and is certainly broader in extending the privilege than other cases which state that tax preparation advice is not protected. Let's summarize. In tax cases, attorneys routinely hire forensic accountants to assist them in delivering legal services to the client. The lawyer may want the accountant to meet with the client and obtain information directly from him and cloak that in the attorney-client privilege, just as if the lawyer obtained the information from the client directly. The traditional method by which that is done is through an arrangement where the lawyer engages the accountant to become part of the legal team. Under this arrangement, the attorney-client privilege extends to the accountant. Now, this gets down to the nitty-gritty. How to create an airtight Kovel agreement. And this section comes from my personal experience, from trial and error, and from a great deal of research into this topic. So what I'm giving you here is some keen insight into my advice for how to create an airtight Kovel agreement. And it essentially consists of 3 steps. So number 1, a written Kovel agreement that is specific to the client and the case must be drafted. And that's for reasons that you might already guess. Number 2, the attorney should engage the Kovel accountant and not the client. This ensures that the accountant is working for the lawyer and the client. Third, a new accountant rather than the client's existing accountant should be hired, and the roles of the original accountant and the new accountant must be delineated and or kept distinct so that the new accountant is cloaked in the attorney-client privilege. Now, you're going to have a great deal of pushback on that. 9 out of 10 times, the client is going to want to go with his existing accountant for any one of a number of reasons. But here's why you want to hire a new accountant and not use the old one. And I apologize for the small font here, but these are critical points, then each one has to be covered individually. First, we all recognize that the accountant-taxpayer privilege is narrow. So it's unlikely that the information and documents obtained by the preparer who prepared the original return will be privileged. I'll say that again. It's unlikely that the information and documents obtained by the preparer who prepared the original returns will be privileged. At the same time, in preparing the amended returns, the preparer, regardless of whether he's the original preparer or a new one, is likely to uncover additional information. And that additional information has a potential to be harmful. Well, what do I mean by that? The additional information could well confirm that there were serious problems with the original return, and it might even prevent to the fraud. And this is where things could go south fast. If the original preparer is used to amend the returns, he may not be able to distinguish between what he learned prior to the time the Kovel agreement went into effect and what he learned after the time the Kovel agreement went into effect. The significance of that is this: only what was learned within of the Kovel agreement is protected by the attorney-client privilege. In other words, any information that was learned before the Kovel agreement went into effect is fully discoverable. It's par for the course. In other words, if the government drops a subpoena on the preparer demanding records and documents that he relied upon pre-Kovel, that information has to be turned over to the government. And here's the danger in all of this if we're using one accountant, the original accountant. If defense counsel cannot convince the judge that the information subpoenaed by the IRS was obtained within the scope of the Kovel agreement, the judge will order the defense to turn it over to the government. As I've already mentioned, it'll be fully discoverable. So the danger here is that documents that were relied upon by the preparer, perhaps after the Kovel agreement went into effect, could now be misconstrued to have been relied upon by the accountant prior to the time the Kovel agreement went into effect, and thus discoverable. And those documents could be the smoking gun that the government needs to bring an airtight case against the client and ultimately obtain a conviction. This is why it's so important to hire a new tax preparer when a government investigation is launched, or even before that, in a scenario where there is an eggshell audit that's occurred or occurring. So there are no doubt a number of obstacles that you'll have to overcome when dealing with your client. As I've mentioned before, he's surely going to want to use his own accountant, and he'll cite any one of a number of good reasons, from budgetary concerns to relationship issues to comfort level. The big one here, of course, is budgetary concerns. The client, of course, is laying out a substantial amount of money for his legal defense, and he's, of course, not looking to incur more costs by hiring a forensic accountant. However, you have to convince your client that this is not a risk worth taking and that he should start out fresh with a new accountant. However, there will always be times when the budget truly does not permit for hiring and when there's no other choice but to use the existing one. In those cases, precautionary steps have to be taken to ensure that information obtained during the course of the Kovel engagement is kept separate from information that was obtained prior to the engagement. The good news is that properly executed, a Kovel agreement gives the taxpayer's preparer the freedom to communicate with the taxpayer and his attorney, ensuring that the taxpayer gets the best possible representation. Now, as I mentioned earlier, there are a few special bonuses that I'd like to give away. And if you've made it this far through the webinar, these are certainly available for you, and I encourage you to download them. The first is a free sample Kovel agreement. Of course, I make the following disclaimer: it is only a sample, and it is far from being complete, but it at least will give you an idea of the important points that need to exist when drafting a Kovel agreement. It can be found right here at this URL. I apologize for the length of the URL. I'll leave it up for a few seconds so that you can at least copy it down. Bonus that I have for you is a blog post that I wrote a while ago. It's called "The Greatness of Mickey Mantle and Louis Kovel." It is available on the DeBlissLaw.com website at this URL. My apologies once again for the lengthy URL. This was the best I could do, however, to guide you to it on my blog. If you prefer, you can go right to the DeBlissLaw.com website, click on the link to Tax Chat, and you can search any one of you can search the title of the blog and it'll come right up. It was published in Global Tax Weekly, a CCH publication, back in February of 2015. Finally, as I'm sure you probably know by now, I love to get feedback from viewers and from readers of my blogs. And so I encourage you to reach out for me anytime you have a question or a concern, or want to go over something that I've covered in anything during this webinar series. I certainly hope that you've enjoyed it so far. There is one module left. That module will be on international evidence gathering. So I look forward to seeing you in Module 4, and hope you got a lot out of this module, and we'll see you again shortly.